Hello and welcome. I am Professor Raman and this is Module 10, the International Criminal Court. We will begin with the history of the International Criminal Court. This of course begins at the Rome Conference. During the 20th century, even the most flagrant violations of international law went largely unpunished, creating a culture of impunity. In the wake of the Second World War, the Nuremberg and Tokyo tribunals were established. In 1948, as we have discussed in previous modules, the Convention on the Prevention and Punishment of the Crime of Genocide was adopted, and the United Nations General Assembly first expressed the need to establish a permanent international court. In a sense, this court would be able to look into all kinds of massacres which had been perpetrated that constituted a violation of international law. The notion of the international criminal justice system re-emerged after the end of the Cold War. However, amidst the negotiations on the creation of the ICC statute, there was constant planning and execution of heinous crimes in the territories of former Yugoslavia and Rwanda. Thus, the United Nations Security Council established an ad hoc tribunal for each of these situations in former Yugoslavia and Rwanda as a response to these atrocities. Of course, you and I have studied these tribunals in a foregoing module. Undoubtedly, Rwanda and Yugoslavia played a significant role in organizing the conference which established the ICC in Rome in the summer of 1998. Human rights activists had strongly advocated the idea of prosecuting serious international crimes, such as genocide, war crimes, crimes against humanity, by establishing a permanent court. This idea was given effect to in 1998 when the Rome Statute, so called because the conference took place in Rome, of the International Criminal Court was adopted at a diplomatic conference convened by the United Nations. The United Nations Conference of Plenipotentiaries on the establishment of an International Criminal Court. This came to be known as the Rome Conference. It took place from the 15th June to the 17th of July 1998 in Rome, Italy. The end result of 5 weeks of deliberations was that out of 160 nations, 120 voted in favor of the adoption of the Rome Statute of the International Criminal Court. Only 7 states voted against the treaty. These were the United States, Israel, China, Iraq and Qatar, amongst others, while 21 countries abstained. In 1995, the negotiations for the establishment of an international body that would look into the matters of the gravest breaches of humanitarian law began with a UNGA resolution, convening a PrepCom on the establishment of the ICC. These negotiations, from start to finish, were a process and part of the culture, logistics, physical locations, etc. of the United Nations. This characteristic profoundly affected the other aspects of negotiation, such as who would be the primary actors, who are the non-governmental organizations, and most importantly, the physical and financial resources to be dedicated to this new body. The negotiations were carried out on an existing basis and not on the accumulation of individual proposals. Thus, the discussion over an issue could be in relation to the entire textual draft of the statute. Subsequent to the discussions, any changes or suggestions to the draft would be added and the revised draft was issued to the parties. Further, this led to the delegation of combining suggestions which gave the states more support for their proposals before the formal discussions. By the last week of the conference, only a few issues were left to be settled. Most important among those issues was the issue of jurisdiction. This matter fell into the hands of the Bureau of the Committee, of the whole and associated delegates under the chairmanship of Philip Kirsch. Of course, Philip Kirsch went on to become the president of the ICC when it was formed. The proposed settlement, the first president, the proposed settlement on the contentious issue of jurisdiction was in conformity with the text of Articles 12 and 124 of the Charter of the United Nations, and thus was added to the final treaty. At the United Nations, voting is discouraged, since it is believed that voting will lead to confrontations and oppositions, which would ultimately weaken the object of the resolution, even if the nature of the treaty is not as such binding. However, it was very clear by the end of the negotiations that only a minuscule minority would oppose the statute in toto. Therefore, it was safe to carry out a final vote. And in fact, this final vote was necessary to further the confidence in the text of the Rome Statute. As students of international law, you would know that treaties can only be adopted when a certain number of states have adopted it by signing the text and then by ratifying it. The Assembly of States Parties is composed of representatives of the states which have ratified or acceded to the Rome Statute. This is one step ahead of a simple signature. The Assembly is the court's management, oversight and legislative body. Over 122 states are now parties to the Rome Statute as of May 2013. In the Assembly, each state party has one representative who may be accompanied by alternates and advisors. The statute also provides that states parties can carry one vote each. However, the best effort is usually made to reach decisions by consensus. The states that are not parties to the Rome Statute may take part in the work of the Assembly only to the extent as observers warrant. They have no right to vote whatsoever. In the meetings of this ASP or Assembly of States Parties, the President of the Court, the prosecutor and the registrar or their representatives may also participate as appropriate. What are the crimes within the jurisdiction of the ICC? The ICC is able to exercise jurisdiction over the most serious crimes of international concern, an umbrella term that includes genocide, crimes against humanity, war crimes, terrorism and aggression. Yet, the court has not been able to exercise effectively its jurisdiction over any alleged act of aggression. But in all the other four categories, the court has exercised jurisdiction. To exercise jurisdiction, it first requires the statute to be amended by adding the definition of that crime. This was done by the creation of Article 8 bis, which gave the definition for aggression. Cases are referred by the United Nations Security Council to the ICC and bind the non-party members to provision of the Rome Statute. It is a recognized principle of international law that the ICC has been granted true universal jurisdiction with respect to nationals of all members of the international community only when the situation is referred by the Security Council. This understanding of universal jurisdiction is not delivered from customary international law, but from Articles 1 and 24 of the Charter. It is derived from Article 1 because Article 1 lays down that the main purpose of the United Nations is to eliminate threats to international peace and security, and that the international community must take effective steps to that effect. This is one of those steps. Article 24 furthers this imagination and says that all states confer upon the Security Council the primary responsibility for the maintenance of international peace and security. Once again, this gives the Security Council the right to act on behalf of all the states. In terms of jurisdiction, the ICC has given itself, under the Rome Statute, the right to exercise universal jurisdiction in absentia in cases of international crimes of genocide, war crimes or crimes against humanity. In accordance with the purpose of the Charter, which is to maintain international peace and security, the ICC's universal jurisdiction in situations referred by the Security Council are based upon the idea that each state has an interest in prosecuting the most serious international crimes defined by the Rome Statute. As I explained before, these are the crimes of genocide, war crimes, crimes against humanity, terrorism, and now with the addition of 8 bis, aggression. In the case of Bosnia and Herzegovina versus Yugoslavia, the International Court of Justice was of the opinion that the obligation of each state to prevent and punish the crime of genocide is not territorially limited. This raises an interesting challenge to the use of the ICJ as a mechanism for prosecuting international crimes. When the case is being investigated or prosecuted by a state which has jurisdiction over it, the ICC cannot intervene. Secondly, when a case is being investigated by a state which has jurisdiction over it and the state has decided not to prosecute the person concerned, the ICC has to first preclude the possibility that the state is unwilling or genuinely unable to carry out the investigation or prosecution before it can admit the case. And thirdly, if the person concerned has already been tried for the conduct which is the subject of the complaint, the principle of ne bis in idem. And fourthly, if the case is not of sufficient gravity to justify further action by the court. Thus, the key consideration for the court to admit a case is whether a state is unable or unwilling to investigate or prosecute a case that either falls within their own jurisdiction naturally or under universal jurisdiction. The criteria for what this means, what is this inability, are clearly provided in Article 17, Clause 3 in an objective way. There have been multiple attempts for creating an international tribunal with primacy and supremacy. With the enactment of the Rome Statute, the international community took its first steps towards the institution of a permanent court with supranational jurisdiction. The Rome Statute of the International Criminal Court is considered as a major landmark in the development of international criminal law to provide for accountability. The statute in its preamble affirms that the most serious crimes of concern to the international community as a whole must not go unpunished. It is therefore a codification of the consensus among states that the culture of impunity must end. It is also a codification of existing customary international law as far as the crimes of genocide, crimes against humanity, and war crimes, crimes that have collectively shocked the consciousness of mankind and affected and debilitated the interests of the international community towards peace as a whole. The prohibition of these crimes has become part of the fabric of jus cogens, and every state has therefore an obligatio erga omnes to punish it. This comes from the lore of universal jurisdiction and the understanding that jus cogens offences are violations of peremptory rules of international law. Who are the members of the ICC? Membership is available to only those sovereign states that have ratified or otherwise become party to the Rome Statute. The process of ratification is not laid down by the Charter. Paragraph 10 of the Rome Statute lays down that the International Criminal Court shall be complementary to national criminal jurisdictions. Article 1 of the Rome Statute provides that an International Criminal Court is hereby established and that it shall be a permanent institution and shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern, as referred to in the statute, and shall be complementary to national criminal jurisdictions. This is the principle of complementarity, that the functioning and jurisdiction of the court shall be governed by provisions of the statute. Complementarity means what we discussed earlier, the lore of unwilling and unable, becoming the precursor for the ICC to step in. Most sovereign states in the world were involved in the drafting of the Rome Statute. So, on the one hand, the court exercises jurisdiction over major crimes, and simultaneously its scope is restricted by the principle of complementarity, as national jurisdiction comes first and the ICC is the second. This was a deliberate move to give individual states the onus to prosecute, failing which the preamble of the statute expresses that the consent of states parties to establish a permanent court with an ultimate objective to put an end to impunity for the perpetrators of these crimes. By virtue of being a party to the statute, the states have given their consent to actively take part in the prevention of these heinous violations of international law crimes and to ensure effective prosecution by way of taking adequate measures at the national level and by embracing regional mechanisms, including international cooperation at the highest level. Most importantly, the permanent court's idea of complementarity comes to reinforce the importance of national criminal jurisdictions in situations where trial procedures may either not be available or may be politically rendered ineffective. In a sense, complementarity furthers the idea that every state has a stake and is duty bound to exercise its criminal jurisdiction over its own perpetrators for violations of international law. The idea is to enhance national jurisdiction over core crimes prohibited in the statute, but also to create a level of awareness among international community to create a mature national legal system which meets the necessary requirements of investigating and punishing perpetrators of crimes listed in the statute. But an inevitable consequence of this concurrence of jurisdiction over the most serious crimes, which are a violation of both international law and municipal law, is that national courts and international institutions conflict with each other. These conflicts are bound to arise between the two systems. The principle of complementarity doesn't really inhibit these conflicts. Complementarity, in fact, also requires states to adopt the same substantive law as that laid down in the statute and to punish all crimes listed in the Rome Statute. Now, not all of these may be recognized domestically. Paragraph 4 of the Rome Statute's preamble affirms that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. How does one enforce the decisions of the ICC? The ICC relies for implementation of its work on national governments. International community is quite critical about it because the ICC's decisions don't mean anything. Lacking an enforcement mechanism of its own, the ICC depends on two elements to ensure that its decisions are more or less implemented. These are the national government, which in many cases doesn't have the political will to cooperate, and sometimes through international pressures, which are also a soft way to ensure compliance. Essentially, this lack of an enforcement mechanism mimics the same realist challenge that plagues international law in general. Without a permanent and effective enforcement mechanism, how can international law be law? Thinking about this question is a good point to end this module on understanding the International Criminal Court. Thank you.